I'm originally from Joplin, and I worked for many years at KODE, the Big Nickel. Graduated from Missouri Southern here, so it's great to come home and give presentations to artists like you. So, great. So we will. I'll set the tone here for what we're talking about with this fabulous quote from Mark Twain. And he wrote this in 1902, 1903, and I will tell you, things have gotten even worse. So it may seem like there's a lot to it, a lot of layers, and there really is. And one of the, I guess, barriers to copyright law is that technology and our know-how changes quicker than the law does. So like, for example, the main act that we are under, now it's been revised several times, but the main copyright law that we're under went into effect March 1st, 1978. Well, a few things have kind of come along since 1978, right? CDs, the internet, right? All of those kinds of things. And so, and then trying to get the law to protect your works online is even further behind. So, now that I've brought the room down and everybody's depressed about it, we will talk about law, which I guess probably will make you feel even better. So, all right, let's give me a few bullet points about what copyright law is, and then we'll go into what comprises a copyright, work-for-hire issues when someone commissions you to do works or you commission someone else to do works. Also talk a little bit about infringement and give you plenty of time to ask questions and things like that, because there's always interesting fact patterns with regard to copyright law. So copyright law is part of an overall area of law known as intellectual property. But, you know, actually, before I get started, let me just get a sense of what kind of art and artists we have here. How many of you are photographers? Photographers here? Okay. Sculptures, painters, like that? Okay, all right. Writers? Okay. Musicians? Oh, okay. And who else? Who else? What are you if you didn't raise your hand?
Art of business law.
Okay, all right. What
Theater.
else?
Jewelry.
Jewelry? Okay, great.
Theater.
Museum.
Museum. Okay, theater. Great.
Therapeutic art in the schools.
Okay. Okay, great, great. So copyright touches on many of you, maybe not in big ways, but in some of you maybe in a very big way. So I try to kind of give this information so that it kind of hits on everybody's area, but if you have any specific questions about like you know, your particular area, then feel free to ask them when we get to the Q&A portion of the presentation. Okay, so let me get back to it. Intellectual property, that's this giant area of law that encompasses not only copyrights, but patents, trademarks, business names, things like that. Also trade secrets, trade dress, unfair competition, all of that. So copyright, and I will periodically abbreviate it as CR. I know that's a very fancy abbreviation there. Think of it as a monopoly right. A monopoly right that you have over your what are called works of expression, or your expressive works. So when you hit the requisite elements of what a copyright is, and I'll talk about what those are in just a moment, you get certain monopoly rights over that work. And it's thought of as a bundle of rights, and I'll talk about what those are in just a second. But they are monopoly rights that you can control, that you can license, you can sell off, those kinds of things. And so that monopoly control over your literary or artistic works is thought of as an economic incentive for you to create. If you have this monopoly right over it, theoretically you will license it out, you will make society better because we have access to your works, you'll make a little cash along the way, use some of that cash to make more works, and so on. Now, of course, every artist that I know, they make art because they are drawn to it, they're called to it, right? But at least from a legal perspective, it's an economic incentive. And so the primary purpose of copyright is to provide that monopoly economic incentive. One of the other things about copyright, and this is just a few bullet points before we get into some of these other things. Copyright law protects the expression of an idea, not the idea itself. And the reason I bring that up is because a lot of, when I do these lectures, and I've done them in St. Louis, Kansas City, other places, I'll have artists tell me that someone stole my idea. Right? Or how do I protect my idea of something? Unfortunately, copyright actually doesn't protect an idea. It protects the expression of an idea. So I'll give you sort of an example. Let's say that you have an idea for a story. It's a book. Boy meets girl, boy's family hates girl's family, boy and girl commit suicide at the end. Now what is that? Romeo and Juliet, right? It's a classic sort of tragic love story or whatever. But as long as that idea of a tragic love story is not protectable, but how you express it, like with names, places, plot portions and things like that. Once you get into that specific stuff, the expression part, that's what copyright protects. But that central idea, like I said, of a tragic love story, not protectable. A few more things for you. Luckily for non-artistic people like me, there's not necessarily any degree of artistic expression needed in order to have a copyright. Just what the law says, just some effort. Just a little bit of a, oh, here we go, right? It's art. Thankfully for me, that's how it is. And so, as I mentioned a second ago, that think of copyright as a bundle of rights. A few more things here. Copyright law does not protect facts, names, titles, short phrases, things like that. I'll have people come up to me and they'll say, hey, I want to copyright my business name. That's not the right area of law. You want to trademark your business name. It would be nice to copyright because copyright costs $35, a trademark costs $125. It'd be nice to go the cheaper route, right? But that's not what it does. It doesn't protect those things. They may be protectable under other areas of law, just not copyright. And one of the really great things about copyright is that it is one of the actual few rights mentioned in the Constitution. A lot of the rights that we consider and hold dear today really aren't in the Constitution. They came later in the form of the Bill of Rights, right? First Amendment, and all that kind of stuff. Right? But in the Constitution itself, amongst the dividing up and checks and balances and all that kind of stuff from government class, remember that? Founding Fathers thought that the protection of works of expression was important and put it in the actual Constitution. So when you are creating and writing and doing whatever, you are exercising your constitutional rights. Round of applause for you. So Section 8, Clause A. And so from this few sentences here, an amazing amount of copyright law. Now, copyright and also patents come from this clause as well. So from that, just a huge amount of law that has developed over the last, well, since the Constitution was put in place. Mercifully, copyright law, there's only one body of copyright law. We're dealing with federal law. We don't have 50 different copyright laws, and so we're dealing with one area of law, and if there's an infringement action or something like that, it happens at federal court. So that kind of keeps it a little bit concise. And I mentioned a second ago that all of the works that are created after March 1st, 1978, which is when the most recent act went into place, are protected under the Copyright Act of 1976, which went into effect in 78. I don't know how that works. I don't know. But, I guess if you think about the government, it makes perfect sense. Okay, so let me give you the elements of what a copyright is. It doesn't take much to have one, right? Just some expressive effort. But that expressive effort has to comprise 3 elements. And it's really easy, especially if you're artistic folks like you, right? No big deal. The first one of these is originality. Originality just means that you created it. You didn't swipe it from somebody else, although derivative works, which we'll talk about in a second, can also be protected from copyright. At least for the purposes of this first element, all it has to be is original. So I'll give you an example. Anybody gone out to the Grand Canyon? Okay, I haven't, but I'm sure it's low. So imagine that you go out there and you go to the lovely South Rim, right, where it's that big photo op, and you step up to the edge of the Grand Canyon and you get ready to take a picture, and you're probably flanked by tourists on this side taking pictures and tourists on this side taking pictures. And for all intents and purposes, those photos are pretty much going to be the same, right? I mean, some little differences here and there, but it's essentially everybody's taking a picture of a giant hole in the ground, right? Even though each one of those pictures are pretty much the same, For the purpose of copyright, they're original. Each one of those photographers made an original creation by snapping that shot. And so that's an example of originality. Don't necessarily equate that with uniqueness. The second element is kind of a nod to copyright statute, which delineates different categories of copyright protection. So work of authorship just means that whatever you're creating fits into some category that's delineated by the statute. So literary works, photography, sculpture, architectural works, choreographic works, those kinds of things. And those categories are construed very broadly. So like, for example, software code, HTML, blah, 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 that's considered a literary work for the purposes of registering a copyright. So it's construed broadly. And so what that means is, I doubt anyone could create anything that isn't somewhere in the statute, right? So you've got originality, and then some work of authorship that fits into one of those categories delineated in the statute. And then the last one here is fixation. What that means is whatever the creation is fixed into some medium that can then reproduce it. And what that means is that the work is now permanent in some way. So if you're a painter, you've painted it on a canvas, there's your fixation. If you are a musician and you have recorded your song onto some type of recording device, there's fixation. If you have taken a picture and it's on some memory disk, or you've even printed it off onto prints, fixation. That's all you have to do in order to hit that element. So then from that, we get the legal definition of what a copyright is. It's an original work of authorship that is fixed in a tangible medium of expression. Now I'm going to try to not be all legalese on you tonight, but that's some legalese right there, straight from the statute. Now you'll notice in those three elements, I didn't say anything about putting a copyright notice, on your work, like a Circle C. I didn't say anything about that. I didn't say anything about registering your copyright with the Library of Congress. That's not required either. All you have to do in order to get a copyright is have an original work of authorship that is fixed in a tangible medium of expression. At that moment, when you have those three elements, copyright protection begins right then and there. You don't have to register it. Now, when I played in bands, I say that I was a frustrated guitarist, which meant I played bass. So, even back then, in the mid to late, when I was in a band, we would record it off onto a cassette and then mail a copy of the cassette to us, and then we kept it in the sealed envelope. Right? You don't need to do that anymore. You haven't needed to do that since 1988, when there was a change in law. And this is how this tells you a little how the U.S. is kind of slow when it comes to copyright law. In 1988, we signed on to what's called the Berne Convention, which is this kind of international treaty that tried to kind of harmonize some of the various copyright laws from around the world. We signed on to it in 1988, a full 103 years after every other country did. So when we signed on to it, finally, we gave up the requirement of having to register a copyright in order to get copyright protection. So we'll talk about the registration system. I mean, it's a good idea, but it's not necessarily required in order to have a copyright. So you've got originality, work of authorship, fixation, copyright protection begins at that moment, and then you're given certain monopoly rights to your work. This is the bundle of rights that you are given. And I say it's a virtual monopoly because there are some expressions to it, namely probably a concept that you've heard of before called fair use. Probably heard of that concept before. We'll talk about what that means. And so these are your monopoly rights, the bundle of rights that you are given by having a copyright. The right to reproduce the work, or license that right to somebody else, to sell it outright to somebody else. So reproduction, the right to prepare derivative works. Derivative works are new works that are based on some other work. So like, for example, you write a book, somebody wants to write a screenplay based on your book, that screenplay would be a derivative work. In order for someone to make that screenplay based on your work, assuming it's still protected by copyright, they would have to get a license from you to do that. Now, it's not called the derivative work license. It's usually called, like screenplay deal or something, it's like some big words with whereases and heretofores and all that kind of stuff, right? And hopefully lots of dollars on it. So derivative works, then distribution, performance, and then also display. So depending on what your type of art is, you might be impacted by some or even all of these areas. Now usually what happens if somebody wants to say distribute, let's say you write a book, somebody wants to distribute it. There's not going to be two separate contracts, one to reproduce your work and then one to distribute it. They're probably just going to be all together, right? But essentially what they're doing in that distribution agreement is licensing your work for a certain amount of time. So this is the bundle of rights that is referred to when you have a copyright. And so one of the great things about copyright is it is a wonderful protection for your works. But the government puts the onus on you as the creator to protect that work. If you find somebody is infringing your work, then the law's there to say, all right, let's go get them. But until then, it's up to you to monitor what people are doing with your works. If someone has licensed your work and that license is expired, are they still selling it? Have they licensed your picture for t-shirts and coffee mugs, but now you're seeing that picture on calendars, right? Those are some things to consider. So once that copyright protection begins, it lasts for a certain amount of time. Copyrights don't last forever. So anything that you create today will last the rest of your life, long may you live, plus 70 years after you pass on. That way your children and grandchildren can enjoy the fruits of your copyright labor. Maybe they'll move out of the basement. So, and this was a recognition of signing on to the Byrne Act too. It was lifetime of the author plus 50 years. Sonny Bono, one of the few things he did in Congress before his untimely demise was extend copyright protection for another 20 years. Once that duration lapses, once that 70 years is gone, the work falls into what's called the public domain. What that means then, it is free of copyright protection. You don't have to go find who owns the rights, because they no longer own the rights, they're gone. So you don't have to pay a fee, you don't have to pay a royalty or anything like that. So no one can prevent you from using the work if it's in the public domain, but also you can't prevent anybody else from using it, right? So that's why, like when you go, speaking of Shakespeare, when you go to the bookstore, there's like, 50 different Hamlets to choose from. It's because that work is in the public domain. They don't have to pay for it. And so all they have to do is, obviously pay to print it. Now, anything new that they add to that work is protectable. So like, for example, whenever I have had the misfortune to read Shakespeare, it'll have like the original Shakespearean text on one page and then sort of the translation of what he really meant, right, in modern English on the other side. That is probably a newer work, and so it probably would be protected by copyright. But the underlying Shakespearean work would not be. It's in the public domain. So one of the things to be careful of, and one of the sort of maddening things about copyright is, since registration is no longer required, it's hard sometimes to find out who owns a work. And I know a lot of artists who go to estate sales, who go to flea markets, they buy old photos, old postcards, incorporate those into their designs and stuff like that. Even though it's old, don't assume that it's in the public domain. So what happens is there's a little bit of risk there, right? There may be someone out there that owns this copyright. They may not even know they do, because the original designer has passed on. It descended down to his or her children or something like that. They may not even know that Grandpa was creative, right? And so that's a difficulty. Now, sure as shooting, if your work becomes successful and making lots of money, well then they all come out of the woodwork, right? And they're doing this. They're like, no, more zeros, right? That happens frequently. So there is some risk there in the fact that while it's easy now to have a copyright, you don't have to register it. For those who want to use the works of others, it can be very difficult tracking down who owns what. And it's not one of those things where you can say, hey, I really tried to find the person, and now I shouldn't be on the hook for infringement. The problem is, and further complicating things if they weren't complicated enough, is copyright law is thought of as, and I promise not too much legalese, but here's some more, a strict liability tort. What that means is, it doesn't matter what the intent of the wrongdoer was. So if you are, if somebody accuses you of infringement, pleading innocent, I didn't know, or I really tried to find the owner, is not good enough. It doesn't matter if you meant to do it or you didn't mean to do it. You could be potentially on the hook for it. Okay, so falling into the public domain, and don't assume that just because it's old, it's in there. Like for example, the song Happy Birthday, it's still protected by copyright. And it's well over 100 years old. That's why when you go to some restaurants, they kind of do their own little happy birthday, blah, 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 whatever. I try to avoid restaurants that do that, but it happens. The reason they do that is because they don't want to pay the licensing fee for that work. And so every day that song rakes in thousands and thousands of dollars because it's placed in films, it's in commercials, or other types of licensing situations. So I'd really like to write one of those songs. And it's very controversial because the reason it's still covered under copyright is that there were some laws that were passed, and some of those laws were retroactive, which is controversial. Some say that if they're going to pass a law, then it should start from then forward, not then on someone else. If it's your employer, and when I mean by employer, I mean like you actually work for this place, W-2, Social Security, things like that. You don't own that work, your boss does, or the company that you work for does. It's automatic, you don't have to sign anything, that's just the way it is. But when that work is created or you're commissioned by someone and you're not an employee of them, you're a contractor, then there's this little wrinkle in copyright law that says even though they pay you for the services, even though they may actually take the work and there's no trace of it that you even made it, you still own the copyright. And so it's important to know that there's a distinction between the copyright to a work and the work itself. Because copyright is something intangible. It can be comprised in that painting that you did. But even if you sell off all the copies of the painting, if you didn't sell off the copyright, you still can control what happens to that photo or that painting or whatever. And this can be very surprising to some clients. Right? They're like, what? I paid you. So here's some examples of when you are creating and it belongs to your employer. Now, this is creation that is done within the scope of your employment. So like for example, if you work at a bank during the day and you play in a band at night, the bank doesn't own your band song. But if you are commissioned as part of your job to write a jingle for the bank, well, that might be something different. So here's some examples of some work-for-hire issues where the employer owns the work. A commercial produced by a radio station employee, story written by a reporter, or design layout by a full-time graphic artist. These are employees. They do this creating within the scope of their employment. The company or their boss or whoever the owner is owns the work. It's automatic. So then that key question is, are we dealing with employees or are we dealing with contractors or freelancers? Most of you probably do this as freelance, right? Or do you work for a creative agency? Anybody work for a creative agency? So the dividing line between what is an employee and a freelancer isn't always just where people agree, hey, are you going to be an employee? Sure. There's 20 factors that courts often look at. Right? Where the work is done. Is it done on the person who commissioned the work? Is it done with their equipment on their property? Or do they just kind of tell you what they want? You go back to your studio and do it in your property. If it's that situation, you're more toward a freelancer. If it's a situation where you do come to their property, you clock in, timesheets, things like that, that kind of weighs more in favor of being an employee. So what happens then is, and I see this a lot with photographers, where like maybe they were commissioned to go shoot a wedding photo, wedding photos or something like that. If in that engagement of services contract, the ownership of the copyright is not dealt with, then the photographer retains that copyright ownership. And you're thinking, okay, I own the air. Thanks, Don, that's great. But it still gives you the right to control that work. And so if they want additional copies of that photograph, those photographs, they have to come to you to do that, or at least get your permission. Because remember, one of the bundle of rights is to make copies, right? So they can't go to Walmart and scan it in and, you know, go around you for that. Now it's up to you. You have to make a business decision whether you want to kind of create that situation. But a lot of times it takes artists educating the client on what a copyright is and what the aspects of it are. Now, a lot of times in the engagement of services contract, it'll include some type of buyout provision where not only are they getting all the copies, but they're also assigning over the copyright. So there can be some trouble in this area, especially when it comes to like collaborative works. If you work with somebody else, you're sort of independent contractors of one another. If somebody is working on your behalf, so let's say that you're a musician, you're making a recording, you're bringing in somebody to play like piano on a couple tracks, you want to make sure that they sign over their rights. Because if anybody creates with you, if it's a collaborative effort, law says that they own that copyright jointly with you. And if you're okay with that, fine. But if not, if you want to own all those rights, then you need to get them to sign those rights. Whatever their rights are, assign them over to you. So not only are there work-for-hire issues when you're dealing with clients, but also when you as an artist engage other people to help you create something. So like in the aforementioned video or wedding photography situation, maybe that photographer hires another photographer to come, you know, maybe it's a really big wedding and they want to, you know, get all kinds of angles, so they hire some kid to help out on that Saturday. They would be an independent contractor and you would want to get those rights over to you. So always be thinking about who owns the rights to the work. So even though this is can potentially be a big area, the reason why it doesn't come up very often is because a lot of artists, they get jobs or gigs through word of mouth. And some artists don't want to kind of create a stink with this, exert their rights even though they might have, they don't want to get a bad reputation, and so a lot of times it doesn't come up. But even though it's kind of a weird little wrinkle in copyright law, it can be handled very, very easily in a contract. And the law says that it does have to be written out in order for that copyright to transfer. And so here's an example of what you might see in an agreement, or if you put this in an agreement, all it basically says is, hey, whatever you create for us, it's a work for hire. It means that we, and that's all you have to do. So a lot of headache can be alleviated by just one little sentence in your engagement services contract. Now, how many of you, by the way, when somebody hires you for your various services, how many of you do get it in written form? All right. Now, I know it comes as no surprise that this lawyer says get it in writing, but get it in writing. The good thing is, and we're not going to talk about contracts too much, but the good thing is it doesn't have to be very complicated. It doesn't have to be 25 pages of whereases and heretofores and party the first part, party the second part, and all that kind of stuff. Right? That's just awful. Sometimes I even see Latin thrown in some of these contracts. I'm like, are you trying to justify your $300 an hour by throwing in these big words? Right? Which is which is probably what is happening. All it needs is just something simple. Names of the parties, bullet points of what you're going to be doing for them, maybe a payment schedule, those types of things. If they decide they want to cancel, maybe they want to cancel halfway through, then they don't get their deposit back, or whatever sort of endeavor you have, all those sort of terms and conditions. A lot of clients, they'll see something like that, they're like, "Whoa, what are you doing?" What you have to do is convince them that it protects both of you. It makes sure that you are both literally on the same page, the four corners of that document, so that you know how much you're getting paid, what you're doing, what various approvals need to happen along the way. Ownership of the copyright is a transfer. If it transfers, then that might increase the fee a little bit. And then there needs to be a dispute resolution section. What happens if things go south and business deals go south? Right? Or somebody decides not to pay. Or maybe you're working with an agency and that agency's client hasn't paid the agency. Now the agency doesn't want to pay you. Well, that's not your problem. It becomes your problem, but you still did the work, right? So you want to make sure that all those promises are memorialized in writing. Now specifically the dispute resolution section, it's almost like a prenuptial agreement. in that you're preparing for the divorce on the eve of the wedding. You're going to put things in there like, all right, if I have to sue you, who gets paid attorney's fees? The winner gets paid attorney's fees. What court will we have to deal with this in? Are we going to have it in Jasper County, Missouri, or is it going to be LA County, California? Well, if you're writing the contract, guess where you should probably put that? Jasper County, Missouri, right? Because I don't think you want to go fight an LA court for that kind of stuff. And sometimes those can be negotiating things. But something like this, handling the work-for-hire issue is pretty
Quick
easy.
question.
Sure.
You sell your item to someone, okay, and there is no contract one way or the other.
Uh-huh.
What about the right then for them to resell it or to display it someplace else? Because that's kind of in your bundle of copyright items.
Yeah, that puts them in a precarious position because you could say, well, I didn't give you that. I didn't give you the right to display it in public. So I'll give you an example. Anybody been to Chicago recently? In Grant Park, there's this giant silver bean sculpture. Everybody calls it the bean, but it's really called the Cloud Gate. There are security guards who work there, and they're on those little, what are they called, segways? When the artist did that work, he licensed to the city, because he still owns the copyright to the work, or portions of it. He licensed to the city the right to display it, which is great. Put it out there in Grant Park, but for non-commercial purposes only. So what that means is, those security guards will stop anybody who looks like they're a professional photographer. Because if they're a professional photographer, they're probably taking pictures of it, to sell it, to put it on t-shirts, to put it on calendars. Well, he didn't license that right, and of course they haven't licensed that right from him, and so he withheld that particular bundle of rights.
So when you, I've seen people taking graduation pictures, wedding pictures, so that's a violation then.
Yeah, potentially. Yeah. If you look professional, that's sort of the guidance, which there's a lot of art schools around there, and so a lot of the students have, nice professional cameras, so they get hassled by the cops. They're not cops.
The copyright cops.
The copyright cops. The copyright cops. Yeah. So that's another reason to get things in writing. Even in the purchase agreement, where it says you're purchasing this painting from me. Just jot a few bullet points in there saying, you get the right of display, and that might be a little bit of educating of the client, because all they're thinking is, I'm paying you this money, I get the work. What do you mean there's all these lingering rights that you have? And especially with regard to visual art, so like paintings and whatnot, there's actually a separate body of law dealing with the right of attribution, that they can't buy that painting from you and then cut off your name. Like if they took it out of the frame and cut it off the canvas, which, come on, I guess people do that, right? It's called the Visual Arts Rights Act, VARA. But in other countries, there's much more protections for the artist, even if they sell the work and it's 20, 30 years down the line. They still get the right of attribution. They still get to have their right to have their name attached to it. The law protects the work from. We feel a little bit differently about those ownership issues. I mean, imagine if you bought a house and somebody who owned it 30 years before you tells you that you can't put in new windows because it destroys the aesthetics of the house. We'd be like, what are you talking about? Get out of here! You can't tell me what to do. And that's protecting those types of rights for artists that has been difficult in the United States, but in Europe and other places, they're very well protected. It's called moral rights. Even though you might not own the work or even own the copyright to it, you still have some lingering rights to it. Okay, any other questions? Great, thank you. Awesome. So, infringement. Not a good topic. We hope it doesn't happen very often. I will tell you though, litigation, and maybe some of you know this already, litigation should be the absolute last resort. Because in litigation, who really wins?
Lawyers.
Right? Well, not me. I don't do litigation. But those guys.
40%.
Huh?
40%?
40%? Is that what they're taking these days?
30 to 40.
Oh my.
Yeah, where'd you take that?
Oh wow. No, wrong business. Again. All right. So, dealing with infringement, you can feel like somebody has sort of, hit you in the gut, right? They're taking your work, they're doing it without permission. How dare they do that? You want to make sure that you try to not keep it, have it at a personal level like that. You want to sort of keep your senses about you, because it is possible to spend a lot of money on something and end up not really having that much at the end of it. So if you recall, we talked about the bundle of rights earlier. Infringement occurs when someone uses one or more of these rights without your permission. Or maybe at one time they did have permission to use these rights, and the license or whatever contract you had with them, maybe that license has expired and they're continuing to still use your work. They've exceeded the license in that way. That would still be infringement. So there's a few things that you have to do to prove infringement. Now, I always tell people, I go, like I mentioned earlier, the law says that it's up to you to go out and police your works and make sure people aren't, taking your pictures off your website, even though they might think, hey, this is a really great photograph, I want it on my website. You still have the right to control that. As, ego boost as it might be, you still have the right to control that. If you find someone that's infringing your work, the difficulty is they may not be just across the street. They might be across the country, across the world, and so like all kinds of business decisions, litigation sometimes is a cost-benefit analysis. Is it worth it to you? Right? But I always tell people that if you find someone who is infringing your work, like they've done a right-click save as, took your painting that you had posted on your website, showing you examples of the kind of works that you've done, and they put it on their website because they really like it and stuff like that. If you find that someone's doing that, don't call a lawyer right away. My lawyer friends probably don't want me to say that. But think of an infringer as a business partner with whom you have not met. Right? Someone that maybe, at least initially, you can say, hey, I see that you like my work. That's great. It looks wonderful on your website. However, I make a living out of licensing these works. And, we can do like a easy little deal. It keeps me happy. It keeps you from, having some potential liability issues. What do you say? Now, sometimes that approach might work and sometimes it doesn't. And if it doesn't, then it's up to you to see how far you want to, if you want to try to contact their internet service provider or things like that, there are options available to you without calling attorneys, because at that point it's very expensive. Very expensive. So, if you have to go that route, and copyright lawsuits happen all the time, most of them don't go to trial because they're so expensive. A lot of them settle out of court. There's few exceptions. Like, I don't know if you heard about the blurred lines Marvin Gaye thing, right? That came down yesterday. Very few of those actually go to trial. More of them are just like lawyers kind of, beating their chest back and forth, and then somebody says, all right, here's some money, right? Which was the example a few weeks back with Tom Petty and Sam Smith, that example. It's hard to kind of get policy from those settlements, because basically somebody totaled it up and they said, all right, well, we might have to pay him this if we have a license agreement with him, or we could pay this much in litigation costs and we might lose, and then we have to pay that on top of the litigation costs. So it doesn't take a mathematician to figure out, let's cut a check and make it go away, right? And that happens quite often. And like other areas of litigation, there are many, many plaintiffs, which is usually where this happens, but also defendants, who have very meritorious cases. Like somebody really did them wrong, but they just don't have the money to fund it, right? And it's too bad, right? That happens in a lot of areas of law. Copyright is no different, and it's unfortunate. And so a lot of law and policy of copyright law is shaped by the big guys. Motion picture companies, record companies, big media companies who have the time, money, and lawyers to lobby and get laws changed and have cases go in their favor and stuff like that. So unfortunately, we get the trickle-down effect of some of that stuff, that these policies favor big companies, not necessarily individual artists, unfortunately. So if you do have to deal with an infringement issue, there are essentially two ways to prove it. There's direct infringement, and it would be great if people who infringed you did it directly. Meaning, they took your work wholesale, put it on their website, there it is. Which would be, first you have to show that you have a valid copyright interest. You do that by doing a registration. You show the court, hey, here's my registration paperwork. Then you show the court, hey, there's my work on their website. So substantial unauthorized copy. That's really easy to prove when it's your work taken wholesale, right? But what happens, and like we saw in the Sam Smith case and in this Blurred Lines case, there's some sort of alteration of the original work. And this is where it gets a little tricky. So in those situations, you have to prove that you have a valid copyright interest. You show your registration. Substantial similarity between your work and then the work that you are accusing of infringement. Now this is where it gets difficult. And I hate to keep bringing up the Blurred Lines case, but it just happened yesterday. What you have in that to prove substantial similarity is you have dueling musicology experts who get up there and they say, well, there's this note and that note, and they form the same chord structure and blah, 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 right? And it's in this motif and all that kind of stuff. I've listened to it. First of all, I'm not good with pop music, and I can handle maybe 10 seconds of the original song, right? The Marvin Gaye song I'm cool with. The other one, unfortunately, I've had to listen to it to get an understanding of what the case is all about, but only about 30 seconds tops. So in that situation, there was some alteration of the original, at least that's what the accusations were. So in this case, the jury said, all right, well, the plaintiff's experts seem to know what they're talking about, we believe them, and so we're going to say there's substantial similarity. One of the other interesting things that you have to prove as a plaintiff, now of course, and that's what the plaintiff has to do, the plaintiff has to prove these things, they have the burden, is they have to show that the defendant had access to the work. Now in this case, with the Blurred Lines song, it's easy to prove access because the song's been out there, it's been out there for many years. What that does is that's a little bit of latitude for people who create things totally independent of one another. It is possible for two artists working in isolation to produce something that is substantially similar to the other one. And as long as they didn't have access to each other, the law says we're going to let those two peacefully coexist. And it happens. How that access is sort of stretched to some of the craziness involving, no surprise, New York and Hollywood. George Harrison. He wrote a song called My Sweet Lord. Came out in 1970 or so, I think. He was accused of stealing the riff, the central riff from that song, from a song that had come out maybe 7-8 years earlier by a group called the Chiffons. The Chiffons had a song, I think it was in the 60s, or early 60s. It was called He's So Fine. And it was on the charts at the same time that some of the Beatles songs were. It went to #1 in the UK for a while, #1 in the US. And so the court said that George Harrison, he may not even been consciously aware that he'd heard that song, but the court said that his conscious mind had heard the song, locked it in his brain for 7 to 8 years, and then it came out in the form of My Sweet Lord in 1970. So that's some of the kind of extremes that the courts look at for access. But for the most part, it's just, hey, do you have access to buy the record? Can you hear it on the radio? Those types of things. So those are the elements that you have to prove in order to get an infringement claim. Hopefully it doesn't get to this point because you're, dueling musicologists, and now I think the judgment was $7.4 million, probably with court costs on top of that, lawyers' fees. It's going to, Pharrell, who's also involved in this, he's not going to be very happy. That song, Happy, he's not going to be very happy. He might have to sell a few of those hats in order to, the Arby's hats, what I call them. So one of the things too, and one of the interesting characteristics, especially with regard to music, but also in literature and other things like that, if you remember earlier I said that copyright law does not protect ideas, only the expression of an idea. So in the music world, for example, one of the things that's not protectable is chord structures or chord progressions. Like, for example, in a lot of songs, I know somebody said you weren't musicians here, but there's a sort of like a stock way that you put a song together. Verse, chorus, verse, some kind of solo, and then, right? bridge, whatever. I mean, those are certain stock things in music, and yet nobody sues somebody else for saying, oh, you have a bridge in your song. Well, so do I. Because those are considered unprotectable ideas. But the notes and all of those things, how you make the song different, that's what copyright law protects. In literature, the same way. A lot of books and even movies have in them what's called a drama curve. Right? There's some sort of inciting incident, the action builds up, then there's the climax where you figure out, oh, he did do it, I killed her. And then there's some resolution, and then credits roll. Right? How many movies have that? All of them, right? But that's an unprotectable idea. Protectable. So, in court cases, then juries have to distinguish between what is something that is a stock feature in that type of creative work and what is something that's an expression. And sometimes that can be pretty tough. But it is one of the things that you have to deal with when you're doing litigation. So I mentioned earlier that the burden is on you to protect your copyrights. If you have to sue, then there's several different things you can sue for. You can sue for actual out-of-pocket damages if you can prove that. But what a lot of people do is they sue for what are called statutory damages. You might not actually have been suffered or have suffered monetarily because of that infringement. You know, like the example I gave that somebody sort of did a right-click, save as, put your picture on their website. I mean, yeah, maybe you lost out on maybe a licensing, but maybe not. Maybe it didn't actually hurt you monetarily at all. The law says, just by the mere fact that somebody took your work without permission, we're going to give you some money. Statutory damages. So if you can't figure out your out-of-pocket expenses, the law says, we will just, here you go. Hopefully this money will be the salve that heals your wound. It doesn't say that in the statute, but thankfully. So, but copyright infringement damages can be very expensive, anywhere from $500,000 to $100,000 per work infringed. If it's found to be willful, sometimes it can be double or even triple damages. Ouch. It can be very expensive, but also very hard to prove sometimes. Anyway, okay, so any questions on that? It's icky, you don't want to go that far, but it does happen, yeah.
In the case where you discover somebody infringed on your work and you haven't registered your copyright, if you run out and register it, is that necessary to do, or can you do it just on?
You will have to register it before you can file your lawsuit.
But you can do it when you find out.
You can do it after the
my
fact. You can do it after the fact, but that does put you out of the running for statutory damages. You would have to prove actual damages for that.
Interesting.
So, and I mentioned registration and stuff like that, and kind of hit on it a little bit. As I mentioned, the registration system is optional. You don't have to do it in order to get copyright protection, but like I just mentioned, if you're going to license your work out, there's potential that maybe there could be an infringement claim out there. You want to get that registration on file. Now, it's $35 pop, so for a lot of prolific creators, it can get expensive, right? It's an online system. You just go to copyright.gov, which is a wonderful website full of very good user-friendly information on these things and more. Now, there are some works that you can register more than one at a time and still only have to pay $35. Songs, now it's one at a time. Photographs, you can, as many as you can cram onto a DVD, $35, right? So unfortunately, they don't give that benefit to all types of creative works for whatever reason. But the $35 that you get, there's a good trade-off in that investment. You get the right to sue in federal court. You get reimbursement of attorney's fees, which is nice. And because if I know that somebody's if the other side's reimbursing my attorney's fees, all of a sudden I become a $300 an hour lawyer. And then what's called prima facie evidence, meaning that you get the presumption that you have a valid copyright because you have that registration. So you get a lot of benefits for that $35. But I always tell people that, especially if you're a very prolific artist, to maybe only register if you think you're going to have a licensing deal with one of your works, or you think maybe there might be an infringement situation. But otherwise, you don't need to have that registration on file in order to have those copyrights.
Are you registering the photo or the item you photographed?
The photo. The photo, yeah, yeah. And that's, there's lots of layers of discussion when it's like, all right, I photographed a photograph. Do I own the photograph? Well, yeah, you own the photograph, but not the underlying photograph. It goes on in many different directions. And I've had people ask me that question, like, well, if I take a picture of the Mona Lisa. No, you don't own the Mona Lisa. It doesn't work like that.
I have a question.
Okay.
I'm on Etsy and I see a lot of people hitting my site for ideas
Yeah.
and I've had people ask me to make them an earring they lost. And
Uh-huh.
I did fall for that twice and I decided, well, I couldn't find the earring. Finally, somebody sent me a picture and said somebody else makes this and they sell,
Yeah.
retail. So, and also I peruse ideas, pictures of other people's jewelry all the time. And that stores in my brain. And
Yeah,
sometimes
yeah.
it comes out in things and then I see other people having.
You are a modern day George Harrison.
That's what I'm saying. So I have to be extremely careful when I start creating that it doesn't come up and match somebody else's, but it's next to impossible.
Jewelry designs in particular are pretty hard to protect. They really are.
Yeah.
Because, you have to show what
Right.
you do in order to get business, right? But by
Right.
doing that, you've kind of exposed yourself.
Right. The only, I guess, if I wanted to copyright something, I would probably make sure it was a heavy-duty, expensive work that I spend a lot of time and effort on and so for a good amount of money.
I would say so. It's just, jewelry is, as opposed to other types of work, it is very prone.
Yeah, but I catch myself and I don't know where to.
Well,
I'm looking at things all the time.
And I got into a debate about I keep bringing up the blurred line situation. I got into a debate with somebody about copying somebody's work or just merely being inspired by it.
Right.
And,
Right.
there's, well, the dividing line between those two things is very blurred. It's a blurred line.
I think the inspired would come from, for me, is seeing a picture of something somewhere and it popping back up in my brain.
Yeah.
Not just looking, I never look at something and say, okay, I'm gonna make that work
Sure.
just like that.
And that would be the
Unless it's a
difference,
study type
Yeah.
situation.
I mean, all of you have people that you see as your influencers, right? People
Right.
that, you admire, that maybe you model some of your work after, and you don't actually just sort of rip them off, right? Or make sort of a knockoff of it, or at least I hope you don't. Like if, back to the music world, if you ever listen to Tom Petty, for example, you immediately find out or think about, well, he probably listened to a lot of music by the Byrds when he was a teenager. But nobody's ever saying that he ripped off any of Roger McGuinn's songs or anything. So there is that inspiration versus downright copying that, the person who claims that you copied them, they're going to say, all right, you've copied me, even though maybe your point of view would be like, well, yeah, there's some similar qualities to it, but it's also like some of these other designs. But jewelry in particular is.
Everything's gonna have some similar quality
Yeah.
because of the medium you're working with.
Well, sure, and that's like the stock features, right? A necklace is always going to have something that goes around your neck. It's going to have some,
Probably made of
sparkly
gold or
things.
silver or whatever.
Yeah, it's going to have certain stock elements. So that's one of the what's protectable and what isn't protectable. But other things too that you want to protect, like if you want to protect your photography online, do like low-res thumbnails. Don't have it set to where they can do the right-click save as. Now, I don't know how to technically do this, but like on your photographs, you can put like on your website like a clear coat, like a clear layer, like through Photoshop. I say these words and I really know what they mean.
You can do like a watermark.
Okay, but well, yeah, you can do a watermark, or you can do like a clear coat over a photo. So if they do a right-click and save as, all they end up getting is that clear coat. Watermarks too. Low-res things. If you post music, little clips that wouldn't be worth downloading. Those types of things. And there are other technical ways that you can do it, but there is some exposure out there, and some artists just see it as sort of kind of look at it like a loss leader. Like, all right, maybe I've sort of dedicated this one to the public, but maybe it'll draw people in. Maybe they'll, want to see some of my other works, or maybe, I can give them access to a password-protected site so I can kind of monitor who comes in and goes out. But there are some ways to do it. There were some hands up over here. Oh my. Arm wrestle for it. Which one? We'll start with you, and then we'll over you, and then back there. Right?
Well, watermarks aren't a guarantee. If somebody has Photoshop, they can cover right over it. So, that's one of the things that I've learned. So, if people are really want it bad enough, they can use your work.
Sure, or not even care that
Right.
the watermarks. I see people on their website where they have taken some stock photograph that they found on Google, and it still has the watermarks from the stock house. I'm like, did you not see that? You know, you always want to assume that anything you find on Google, like a Google image search, always assume it's protected by copyright, unless otherwise defined. But yeah, I mean, I had a student at, not one of my students, but a student at one of the schools where I teach at, did a Google image search, submitted a bunch of photographs she found, called it her own work, including the watermark of the artist who actually prepared the photo. Like, not only is that dumb, but that's just really dumb.
She's not a lawyer now, I hope.
No, or a photographer. Yes.
My question has to do with, I've seen a lot of still life paintings lately, and there are trademarked items within the still life
Okay,
setup,
all right.
like a bottle of Jack Daniels or whatever.
Sure, yeah.
So, that seems to me like dangerous territory. If you're putting that, I mean, I put different things in, but I turn the you cannot see what the actual
Yeah.
trademark image is.
Yeah, and that's, it's getting outside the area of copyright, but into trademark. But yeah, I mean, they would have a right to say, no, you can't, you know. Most, I would say, don't care as long as you're not portraying their mark in some sort of negative light, but they do theoretically have a right to say, hey, you're selling your paintings with, you're selling a painting of our logo, you know, you shouldn't do that or get a license to do that. But yeah, I mean, but even turning it, someone could still look at that and go, that's Bottle Jack Daniels right there. Right? You know, and it's too bad because we live in a logo world, right? We see logos everywhere. I mean, and companies pay big money to have their logos placed in TV shows and movies and stuff like that. But it is sort of, it's dangerous territory, you know. But I see all the time, people will, you know, put out paintings of Velvet Elvis, right? And all that kind of stuff. And all of those things may not be protected by copyright, but maybe areas like trademark. Another area involving someone's image called rights of publicity. You know, you can't do a painting of Marilyn Monroe unless you have their permission. You know, I mean, that kind of stuff. So it's difficult. Thorny areas for sure. Yes, somebody else. Yeah.
My husband always told me it's okay to paint from a photograph that's not yours as long as you change it like what certain percentage is this.
Well, that gets into this thing called fair use that we talked about.
Okay.
You know, and I hear that all the time, like certain things like if I change, you know, 30% of it, then it's original work. You know, and I've heard those for a long time. I'm not sure where those come from because there's no sort of statutory basis to that. Like what she talked about, you often hear the phrase fair use. I'm using someone else's work, true, but it's okay because it's a fair use. Or I hear all the time, well, I'm not making any money with it, so it's okay. Well, probably not. So, yeah.
Going back to, suppose you have a gallery
Okay.
and you have a picture that you know has a copyright violation in it, and you sell that picture. Where does that put you?
Law says you're just as guilty.
Okay.
It's called
That's what I
vicarious. It's
thought.
called vicarious liability. Even though you didn't do the infringing, you helped it along. You know, that's like YouTube, for example. People will put up some copyrighted video. YouTube is on the hook for it because even though they didn't do the infringing, they have created the conduit through which the infringement occurs.
They're neighbors.
They're neighbors, exactly. So how they escape liability is, if you've ever gone to YouTube, you watch a video, you come back the next day and all of a sudden the video's now gone, it's been taken down. That's how YouTube escapes liability. The copyright holder contacts YouTube and says, take that down, that's mine. YouTube says, all right. They take it down and that's how they escape that vicarious liability. The problem is, sometimes maybe those uses do qualify as fair use. Or maybe they don't have the rights like they think they do in a particular item. YouTube takes it down anyway because they don't want the headache. There's an organization called the Electronic Freedom Foundation, or EFF.org. They have on their website what they call the Takedown Hall of Shame. And it's a collection of copyright owners who really have exceeded their rights to take down stuff. A lot of what is taken down is stuff that's critical. Like somebody will do a book review or a movie review and they tank the movie and they show clips of the movie in the review. copyright owner contacts YouTube and has it taken down. Which to me goes beyond copyright and gets into the area of free speech and First Amendment issues, right? Which is very very important to us all. Okay, so did I answer your question?
Yes,
Okay, all right. So don't do what you just.
that's what I thought. Yeah.
Yeah, or in that situation, what you want to do is if there's if someone has engaged your services to sell on their behalf, like a consignment, then you want to have some sort of CYA provision saying, all right, if you create some liability for me, then you have to indemnify me. So it's almost like they become your insurance. Okay, so remember these, our bundle of rights. We come back to them. I mentioned earlier that these monopoly rights are really technically virtual monopolies because there are some exceptions to them. There's some First Amendment principles that are exceptions to them, and then also the concept of fair use. So fair use is not as broad as some people would like it to be. It would be nice if it were. But it's really a very, very narrow exception to that monopoly right. And as artists, you should be happy that's very narrow. Because otherwise people would be using your works all the time and not having to pay for them or even get your permission to use them. So what it does is it gives people, other than the owner, whether you or a company, whatever, limited privilege to use the work without permission and without having to pay a royalty fee. So it's usually limited to criticism, so like movie reviews and things like that. Fair comment and criticism. Parody is also an exception. So parody is actually protected by the First Amendment. Now, even though I say the word parody, there's actually exceptions to the exception. So like for example, you've all heard of Weird Al Yankovic, right? Even though we say what he does is he's parodying a song, for legal purposes it's really not technically a parody because while he is using somebody else's rhythm and beats and stuff like that, he's talking about something else. The law that protects parody says if you're using someone's song to make fun of that song, for example, or you're using their work to make fun of the work, that's what parody, that's what fair use protects. If you're using somebody's work to make a social commentary about something else, not protected. And so in Weird Al's case, he wouldn't come under a fair use protection. He actually gets the license from the original songwriter and actually lists the original songwriter as co-writer with him on his song. So that's why people usually don't mind when Weird Al Yankovic does a version of their song, because one, it means they're relevant, and two, they're getting half the royalties from it. I wish he would make fun of something like that. So things like news reporting, teaching and scholarship, although there are some exceptions to that too. You can't just often show a movie in class. You have to have the performance rights in order to do that. So librarians will tell you, you can check out this video, but you can't show it to a classroom, or certainly can't charge permission for it, or charge admission for it. If you ever put in a video, besides the FBI warning that you see on there, it'll say something like, this movie is licensed for private home use, blah, blah, blah. If you were to show it in a classroom, that's not a private home use, that's a public use. And so you would need to get an additional license to show it in public, which takes a video from 1995 often to 119.95 for those extra performance rights. Now, one of the sort of kind of annoying things or troubling things about the fair use concept is that it's judged on a case-by-case basis. Now, maybe that's where some of these rule of thumbs come from, like what she mentioned about the 30% change and stuff like that, but it's a case-by-case determination. So what that tells you is, you don't, and where this comes up is a defendant makes this defense. They say, sure, I use their work, but it's excused because it's in the category of fair defense, or fair use, rather. Now, I'm telling you this case-by-case, make your case in court. That should tell you that you don't get to say fair use until you've already been sued and you're in court, right? So you've already spent a lot of money and time dealing with this. So it's not like one of those things where somebody calls you up and they say, hey, you're using my work without permission, stop what you're doing. It's not like you can say, well, yeah, it's a fair use, sucker, and then slam the phone down. It doesn't, unfortunately, it doesn't work like that. You have to make this determination in court. So there's a few different factors on how fair use is determined. A lot of people just think, well, if I'm not getting paid for it, if I'm not charging people for it, then it's okay. That's really only one of the factors that courts assess fair use by. One of the first one is the purpose and character of the use. Are you using it for commercial purposes or non-commercial purposes? Are you showing clips of a movie in a not-for-profit school or a public school versus a for-profit school? There are different distinctions. Is it for entertainment purposes or other things? So that's one factor that the court uses. Another one is the nature of the work itself that you're using. Is it unpublished? Is it out of print? Is it a historical novel, which would be full of facts, which probably aren't protectable anyway? Like, if you're taking excerpts from somebody's book about the Civil War, well, they don't own the fact that the Civil War was between 1861 and 1865, right? So are you using those kind of bits and pieces? Is it factual in nature? Is it fictional? Those types of things. So the nature of the work itself also comes into play. And then also, how much of the work did you actually use? And this is sort of a quantity versus quality analysis. You can use a small bit of the work, but if it's the important part of the work, it might not be a fair use. Also, if you use a lot of the work, but it's not that much, not important that much, then it still might be a fair use. So I'll give you an example. A number of years ago, Gerald Ford published his memoirs. I'm sure it was a lovely, riveting read. As with most books that are being published, advanced copies are sent out to various publications to get reviews and comments and stuff like that. The magazine The Nation, which I'm not sure if still publishes.
Yes.
Do they? Are they online only now? Or
No,
okay, great. They got a copy of one of these advanced copies, and they decided to reprint in full detail the excerpt from the book dealing with when the events leading up to when Ford pardoned Nixon. And let's face it, that was probably the only reason that people were buying the book. And so The Nation, they were sued for copyright infringement by Harper and Row, I believe was the publisher. Their defense was, well, it's a small portion of the book. This is a large memoir, and we only published a very small portion of it. The court didn't buy that argument because it was the important part of the book, even though it was a small percentage of the book itself. So quantity versus quality analysis in this third element. And then the last one is the one that you probably think of more is the effect, the economic impact of the use on the work itself. So like if somebody just takes your work without licensing it, that could have a severe impact on your work. A case where this came up about, I guess it's going on almost 20 years ago, was involving Roy Orbison and a band called Two Live Crew. Two Live Crew, well, first Roy Orbison, as you know, has a song called Oh Pretty Woman. Very popular song. He wrote it, and it's administered by a very big publishing company out of Nashville called A. Cuff Rose. Two Live Crew approached A. Cuff Rose, the publishers of that song, and said, hey, we would like to license your work to make a song. A. Cuff Rose said, no. Which they had a right to do. They could say, no, we don't want to license it. Two Live Crew said, well, we're going to use it anyway. And so then they used a portion of the song, like a few stanzas, and then the central riff of the song, you know, that da-na-na-na. They used that in their song called Pretty Woman. And apart from that riff and a few stanzas of the original song, it had no similarity to the original at all. I mean, there's verses like, you know, big hairy woman, it's just, you would have to know Two Live Crew. It makes perfect sense. Well, A. Cuff Rose sued for copyright infringement. You didn't license the work. You came to us. We've caught you red-handed. Two Live Crew, it appealed it all the way to the Supreme Court. And the Supreme Court, in a 9-0 decision, which never happens. Even the more important laws and liberties of our time have been 5-4 decisions, like Roe v. Wade, 6-3, like the Miranda rights case. 9-0, the justices said, parody is protected by the First Amendment. This is a parody of that song. I'm sorry, A. Cuff Rose, Two Live Crew wins. And so one of the defense, or one of the complaints of A. Cuff Rose was, you're damaging the economic value of this song. So it's one of those things where it's very difficult to kind of hang your hat on that because now you're already in court. There's still a chance that you might lose, or the courts might look at it in a different way because it is case-by-case basis. Two courts looking at the same fact pattern might decide the case differently, so there is some risk to that. So from that come a lot of, and maybe this is what you mentioned, sort of some fair use myths that are out there that hopefully I can kind of educate you on a little bit. One of the ones that I hear with regard to music is, well, I can use a copyrighted song so long as I only use less than 8 measures of it. I don't know where that came from. There's nothing in the law that says 8 measures or less. Right this way, sir. Any part of a song that is reproduced, even if it is a mere half a second sample of someone else's work, it is still protected under copyright. A number of years ago, there was a lot of cases that started springing up about sampling, which was a major component of rap and hip-hop music in the late 70s and early 80s, and it still is to a certain extent. Lots of lawsuits there. And even though some of them were just little blips, little drum machine hits and things like that, they still needed to be licensed. We're seeing now lots of lawsuits start being initiated for songs that came out 15, 20 years ago because someone developed a type of software that if you run a song through it, it can detect what samples are in there even though they may not be discernible to the human ear. And so Madonna's song Vogue that came out in 1990 has been a recent subject of litigation because there's buried in there somewhere are some samples to other songs and things like that. And this is just sort of a reflection on the industry as a whole that they sort of kind of lost their you-know-what with file sharing and Napster and stuff like this, and this is a way that they're trying to recoup some of that money. So 8-bar rule, no. Another one I hear, and maybe you've heard this too, well, it's just free advertisement for the artist. I can use their work, but it's an advertisement for them. Well, yeah, that might be true, and thank you for that free advertisement, but it's my work, I still have the right to control this so-called free advertisement, right? And there's something about artists, musicians in particular, but most artists, that people think you like to do things for free all the time. That's not a way to run a business,
It's
right?
good exposure.
And it'll lead to other things. A lot of what I do when I teach courses to artists is I teach them a lot about entrepreneurship and starting to think about what they do in terms of a business. And if you want to make a living out of doing what you love, you can't keep giving it away for free. You can't keep financing it. And there's this attitude out there that it's undignified somehow for artists to talk about money. You seem greedy, how dare you? Well, you're not going to, IGA over here and saying, you're asking too much for that $3 loaf of bread. Will you take $1.50? No, nobody's doing that, right? But somehow for artists, especially young artists, there seems to be that attitude. But I hear this all the time when it comes to free advertisement. You have a right to control that. Another one I hear, well, I own a copy of the insert type of art there. I can do whatever I want to with it, right? No, not unless you've got that copyright, unless the person who commissioned your work also got the copyright at the same time. So it's important to remember, like I said, that there's a distinction between ownership of the work itself and ownership of the copyright to that work. They don't transfer automatically. So like, for example, ownership of a CD or DVD, for example, does not give you unlimited rights to all the stuff that's contained in there. And I see that happen a lot with television commercials and production houses. They bought a CD, so they think that they can now use it for a music bed, put it in commercials and stuff like that. It doesn't work like that. It does not work like that. And even if you have got performance rights like ASCAP and BMI, that doesn't mean that you have the right to use the work in that type of situation. So just because you own it doesn't mean that you can now broadcast it to 1 million of your closest friends on some internet service, right? So we hear that a lot too. Here's one. If I re-record someone else's song, I don't need to worry about getting a license. I'll just re-record it. No, that doesn't work either. You've re-recorded the song. You've used their song while re-recording it. you've now committed copyright infringement by making an illegal copy. Now, I have lots of music examples because that seems to be, music is prone to a lot of copyright issues because people think that they don't have to pay for it. Or 99 cents on iTunes, that's just too much. 99 cents! Pay for the song! Right? Move on. So even if you record someone else's song, you still have to get a sync license. And I remember when I've spent time in Joplin, I've heard songs that have been re-recorded that sound an awful lot like the original because they didn't want to get a license. I'll give you an example of how much money some of these publishing houses make from this kind of stuff. And they protect it very adamantly. I don't know if it airs anymore, but I remember for a number of years down here, and even up in Kansas City, there was a commercial for Branson. And it had the old Doobie Brothers song in it, Listen to the Music. Now, it wasn't the original recording of the Doobie Brothers song, it was a re-recording. And so what happened was, in order to use that song, they had to get a sync license from the publisher to use the song. And then they just re-recorded it so they didn't have to get a license from the recording company. To get that sync license, the company who did the licensing paid the Doobie Brothers, or the publishing company that owns the song, $75,000 a year to use that song. That's a lot of tickets to ball numbers, right? You can imagine, that's just one song, so you can imagine that these companies are very, very particular about how their songs are used, what the licensing is, and stuff like that. So you just don't want to get yourself kind of caught up in that. Especially if they figured out that it's a willful infringement, it could be 2 or 3 times the damages. Another one, and this is the one I hear all the time too, if I don't charge for it, it's not a violation. Even if you don't make any money with it, even if you give the work away for free, it's still potentially a violation. Now the exception to that is there's something called the first sale doctrine, which says if I buy a CD, fair and square, I bought it legally, chain of title came over to me, I can sell it on eBay as a used CD and I don't have to kick the original owner back a few bucks, right? First sale doctrine says I don't have to do that. But if I make a whole bunch of copies with it with my CD burner and then I sell those, well, then you got a problem. Or even if you burn a whole bunch of copies and give them away. Now, the law does provide for a small number of, what they just say, small number of copies. Like if you get a CD, you burn 5 copies and give them out to your friends. Hey, this is a really great CD, what do you think? Law's kind of okay on that. 500, maybe not so much. Or you upload the CD to 1 million of your closest friends on some file sharing website. Yes, you've not made any money with it, but you've certainly had an economic impact on the original work. So small number, what the dividing line is, it's a blurred line. But maybe some of you didn't know this. When CDs became commonplace, when you could go to the computer store and buy a stack of recordable CDs, well, believe it or not, the record companies were a little freaked out by that. And so, whenever you buy media like that, embedded into the price of what you pay is a little royalty that goes back to the record companies. Isn't that nice of you? That's so nice of you to do that. You didn't know you were doing it. You didn't know you were financing the record companies because they got scared. Anyway, so even if you don't charge for something, you show a movie and you're not, and you even don't charge admission for it, there's still a potential situation.
What about video stores?
Now, video stores, because that's their product, there's some allowances for that. That they can kind of just have videos, or a music store. They can have music playing because that's their service that they provide, and so there's allowances for that.
And just out of curiosity, I mean, every teacher in every school will pop in a video on an afternoon,
Yeah.
So, I mean, is that okay? I mean,
No, not usually. Not usually. Like if the teacher brought the video from home, it was just part of their personal collection, they wouldn't have those public performance rights. So it would be a potential violation. Now the teacher wouldn't be on the hook, the school would. Let me tell you, the MPAA, the Motion Picture Association of America, and the Recording Industry Association of America, they don't care if it's a church, if it's a daycare, if it's a school, they will come after you. They do not care.
Disney.
Yeah, Disney coming after daycare centers because they're showing videos, Disney videos in the daycare
Yeah,
center.
you can't even sell some product you make out of material with Disney material on it.
Oh, I'll tell you,
Any registered trade. Yeah.
absolutely. I kind of went to task with these guys. I represented a client when I lived back in Chicago who did moon jumps, like bounce houses, whatever those things are called. I don't know. You get in and you have a good time, whatever those things are. You bounce up. He bought one legitimately from a service that sells these things, and it had some clownfish on it that one could make an argument looked a little bit like Nemo. But they were just clownfish, right? So this law firm contacted him and said, hey, you're using our client's trademarked image improperly. And I had to make an argument, like, you guys do not own clownfish. Right? You don't own them. Well, this is Disney, and in fact, he was going to say, we'll bury you, or whatever. And I was just like, you know what, I'm going to ignore you. This is not worth our time. You don't own clownfish. And then he immediately got another letter from the same law firm saying, we represent Warner Brothers. I'm like, and so what happens is, and that was my first introduction into what are called copyright trolls. These are law firms usually that don't even own, that haven't been retained by these clients, but they go out and try to threaten people to say, we'll sue you if you don't send us money. We'll sue you for $150,000, or you can make it all go away for $5,000. Now, if that isn't an illegal shakedown, I don't know what is. And it's a really, really big problem. There's copyright trolls, there's also patent trolls and stuff like that. And it's just essentially they might own some of these properties. They don't do anything with them. All they are in the business of suing. And it's really, really bad. Any other questions? Yeah.
I mean,
That's the name of the song.
I know, but they named that song that, and they're getting sued for
Yeah, by blurring the line between,
I just,
It is interesting. We're going to see more of those cases because record companies you guys aren't wanting to buy music these days, so they got to get that money from somewhere, right? Yes.
So where does Netflix come into this? I mean, okay, let's say a teacher's going to show something and they just show it off Netflix. I mean,
It's the same situation. It would be just as that they put in a DVD feed.
so Netflix is only for home use?
Yeah. And it's one of those things, how many of you were aware of that? Oh, wow, I can't show. Yeah, I mean, it's, not a lot of people are.
How do you go about, is it a huge hassle to actually get the rights to do that, or how do you go
Yeah,
about
it's just more money. Yeah,
most of the schools do that and have licensing and videos you can show. I mean, that's
Like I bet here at the
standard
Joplin
schools.
Public Library, they have videos that probably have performance rights that what would cost us $19.95, like I said, would cost them $119.95. That extra $100 is those public performance rights. There's a few other, go back here and then we'll come back up here. Yes.
If you walk down the street and you see a house that you like, you take a photograph of it or you paint it.
Yeah.
You don't have the owner's permission, but then you take that and you sell it on your own. Is that a problem with the original?
Unless it's the Rock Hall of Fame.
Frank Lloyd Wright.
Frank Lloyd Wright house.
Yeah.
It's kind of a gray area. I mean, while they own the house, they don't own the copyright to the architecture. It is in the public view, so you're just walking by on the street and you see it. So there's not necessarily a problem with you painting it or taking a picture of it. Where the law kind of comes in is what you do with it afterwards. So like if you just took a picture and put it up in your home, no big deal. If you wanted to sell it to a magazine, Better Homes and Gardens, that might be something different.
What if you sold it like in an art fair or something?
I usually just tell people, when in doubt, just get somebody to sign a piece of paper. And make sure it's somebody who has the right to do that. If it's a rental person, don't get that. Get the landlord, right? It's just, some people will be like, oh, sure, I'll sign it. It's just always better to just, you want to keep the headache away. Especially, if you want to maybe try to get this picture or painting licensed or put in a book or something like that, a publisher's not going to want to mess with that. If they think that there's any sort of encumbrance to your ability to give them the rights, they'll go away, for sure.
What about architecture, a building?
It can be protected by copyright. It's one of the categories, yeah. Even pantomimes, like Marcel, those are protected.
All clowns are.
Yeah, and they get very particular about when somebody steals their routine. I think we had another question, and we'll come up here. And
Yeah, I'm a student, and as a student, it sounds like you're saying appropriation is the same thing as plagiarism.
Yes and no. There is some overlap. Plagiarism is an ethical violation where you didn't attribute the source. Copyright infringement is a legal violation. So you can have you can be within the ethical boundaries of plagiarism by attributing your source, but you can still violate someone's copyright by using their work without permission. So that's why it's not just enough to say where you got the work from. That doesn't necessarily get you out of the copyright infringement problem. It might get you out of the plagiarism area, but not necessarily the legal area of copyright. So copyright infringement does sound a lot like plagiarism, but one's an ethical violation and one's a legal violation. So did you have a follow-up?
So, okay, so there's a repeating pattern. Now, within this new design that comes from probably something that someone else created, we're creating another original design, so that's been protected legally. Is that correct?
If yours is an original design, now if you create something that's based on somebody else's original, that would be a derivative.
It essentially has to be altered to a certain degree to be able to be protected.
Well, that's one of the fair use myths that we were talking about.
Okay.
If you're gonna base something off somebody else's, it's always a good idea just to try to get at some type of derivative work license. Now, if it's a building that's like 200 years old, nobody's gonna own the rights to that anymore. Or if it's just some sort of stock thing in architecture, like it's got columns in front, well, I mean that's a stock thing.